Assalamualaikum warahmatullahi wabarakatuh. My name is Nura Imam binti Asmadi. My matric number is 1201480. Today I will discuss about Daud, the case about Daud bin MAMAT and others versus Majlis Agama Islam and others, 2001. The objective that I get from doing the assignment: first, I can recognize and differentiate between civil law and Sharia law. Second, I can relate the law with the problem that had been happening nowadays. Third, I can sense the logical theory of the law when hear the court decision about certain matter. The introduction of the case. In this case, the plaintiff applied to the civil court for a declaration that they were protected by constitutional provision relating to freedom of religion, given that they had renounced Islam. The issue is whether the plaintiff or the matter affecting the right of the plaintiff falls within the jurisdiction of the High Court of Malaya or the Sharia Court in Malaysia. Fact of the case, the plaintiff of Kelantanese descent of Malay parentage were at the initial stage convicted and sentenced to jail for heresy. Appeals were filed by the Religious Court of Appeal. Mahkamah Raya Syariah had modified the sentences in that the imprisonment orders were set aside and the plaintiff were required to appear at the Qadi's office every month for 3 years. Whereupon they were required to declare their regrets in line with Islamic tenets. The plaintiff had failed to adhere to these new instructions, resulting that the first charge being preferred by them. In addition, the plaintiff did not file any appeals. On 12 November 2000, the plaintiff informed the court that with effect from 16 August 1998, they had already apostatized. Founded upon this confession, they were charged for offences pursuant to Section 102, Clause 3 of the Enactment Majlis Agama Islam dan Adat Istiadat Melayu Kelantan 1994, the second for the charge for second time. The punishment for second charge was still pending. Next, the argument. The plaintiff then filed for originating summons in the High Court of Malaya at Kelantan, praying for several declarations, inter alia the right to profess and practice their religion based on Article 11, Clause 1 of the Federal Constitution, which state that every person has the right to profess and practice his religion and subject to Clause 4 to propagate it. They declared that as they had apostatized, the Enactment Majlis Agama Islam dan Adat Istiadat Melayu Kelantan 1994, which provide the power for the Sharia Court, does not have power towards them. The court decision. The court held to dismiss because that the plaintiff lacked actual grievances upon which to found that declaration applications. Similarly, the second charge could not have been the basis either, as those charges are still awaiting trial, as the plaintiff had alleged that they had renounced their Muslim faith. From their point of view, they had expected themselves to be safely outside the ambit of the Sharia Court and the relevant religious enactments. However, the Section 102 Clause 1 of the Enactment Majlis Agama Islam dan Adat Istiadat Melayu Kelantan 1994 provide for a finding of fact for purpose of ascertaining whether a Muslim respondent, and in this case, the plaintiff had indeed apostatized. Section 102 to provide that a person is still deemed a Muslim until confirmed by the Sharia Court as having apostatized. Thus, civil court has no jurisdiction to hear the matter. Next, the matter of apostasy has been dealt with by the Enactment Majlis Agama Islam dan Adat Istiadat Melayu Kelantan 1994, as the plaintiff were yet to be found guilty of the second charge of apostasy with the proof and provision available. The plaintiff were still Muslim. That being so, the plaintiff being legally Muslim would still remain within the jurisdiction of the Sharia Court. The issue of the plaintiff having been prevented from practicing their religion of choice really did not exist here. In fact, the complaints actually revolved around the issue of their right to apostate. It was undisputed that the plaintiff had voluntarily declared themselves as having left the Islamic faith. The court said that the act of exiting from a religion is certainly not a religious act, or could be educated with the right to profess and practice their religions. A person who renounced his religion cannot be claiming the right to freedom of religion under Article 11 of Federal Constitution. Last but not least, the conclusion. First, civil law and Sharia are very different from the theory and the way it is implemented. Second, each type of law has its own way of deciding the decision, whether it's civil, English law and equity, or Sharia law. Third, every human being has been held accountable in everything he has done, whether it's bad or good. That's all from me. Thank you.